Hello, my name is Golda. I'm a partner in the dispute department of Bentsi-Enchill, Lecture and Ankuma. Welcome to our podcast for today. Today, we'll be talking about enforcing foreign money judgments in Ghana. And this topic is important because increasingly, entities are interested in knowing whether judgments they obtain outside Ghana may be enforced in Ghana. They're also interested in knowing whether if those money judgments are enforceable in Ghana, what the procedure would be to have it enforced in Ghana. In Ghana, there are a few laws that regulate enforcing foreign money judgments. These are the Courts Act 1993 Act 459, and this regulates the procedure for the registration and setting aside of foreign judgments. We also have the Foreign Judgments and Maintenance Orders Reciprocal Enforcement Instrument 1993 LI 1575, and this lists the countries whose judgments may be enforced in Ghana on the basis of reciprocity. We also have the High Court Civil Procedure Rules 2004 CI 47, and this mainly sets out in detail the procedure for enforcement of the foreign money judgments. Ghana is currently not a signatory to any international treaty or convention governing the recognition and enforcement of foreign judgments. However, LI 1575 sets out in detail the countries whose judgments may be enforced in Ghana on the basis of reciprocity. These countries are Brazil, France, Israel, Italy, Japan, Lebanon, Senegal, Spain, and the United Kingdom. And jurisdiction to enforce any foreign money judgments, whether the defendant in the original action was a Ghanaian or was a foreigner, is established on the basis of reciprocity. And usually it's the president who determines the countries with which Ghana will have a reciprocal agreement for the enforcement of foreign judgments with. The president also has the power to withdraw any reciprocal treatments, particularly in instances where Ghanaian judgments are treated unfavorably in other countries. So where Ghana realizes that it has a reciprocal agreement with the country, however, the countries do not treat our judgments as they should, then the president has the discretion to withdraw the reciprocal treatment with the other country. In instances where there's no reciprocal agreement with a foreign country, the judgments in the foreign country will not be enforced in Ghana on the basis of reciprocity, and a judgment creditor will have to institute a fresh action in Ghana and then use the foreign judgments as evidence during the proceedings in the Ghanaian High Court. For a foreign money judgment to be enforced in Ghana, there are certain requirements that have to be met. And these are, first of all, the judgment must emanate from a country which has a reciprocal agreement with Ghana. The foreign judgment must have been granted by a superior court not exercising its appellate jurisdiction. The foreign judgment must be final and conclusive between the parties. And normally we'll say a judgment is final and conclusive if it was delivered by a court of competent jurisdiction as its final judgment and was deemed to be incapable of alteration by that particular court. In that instance, if a judgment is subject to appeal, it will still be a final judgment, given that the High Court that gave the judgment does not have the right to alter that judgment. Further, the foreign judgment must not have been wholly satisfied and must be capable of enforcement in the foreign country. The court of origin must also have had jurisdiction over the parties in the original action. A foreign court is normally said to have had jurisdiction where the judgment debtor was a plaintiff or counter-claimant in the proceedings in the original courts, where the judgment debtor was also a defendant in the original courts and voluntarily submitted to the jurisdiction of the original courts, where the foreign judgment debtor submitted to the jurisdiction of that court by contract, where at the time of the proceedings, the judgment debtor was resident in the country, or in the case of a body corporate, that judgment debtor had its place of business in that country, or where the judgment debtor had an office or place of business in that country, and proceedings in that court were in respect of a transaction effected through or at that office or place. The defendant must have also received proper notice of the proceedings against him. The notice must have been given in accordance with the law of that country, and enforcement of the judgment must not be contrary to Ghanaian public policy. Normally, the basic principle we apply in Ghana on public policy is that the courts will not lend their hands to aid a person whose course of action is based on an immoral or illegal act. A foreign judgment must be certified by a notary public, or must be authenticated by an affidavit signed by a lawyer or a representative of the judgment creditor. It must be sworn before a judge, a magistrate, a registrar, or a commissioner of oaths. If the judgment that is sought to be enforced in Ghana is in a language other than the English language, then it must be translated into English. We can't have a foreign judgment that may be in French, Spanish, Italian, being enforced in that language. So all these judgments must be translated into Ghanaian English, and then they must be authenticated. Normally, the procedure used in enforcing a foreign judgment is by application to the High Courts, and this is normally an ex parte application. So this means that application is made not on notice to the other side. So the judgment debtor will not be aware that such an application has been filed. And the application must attach a copy of the judgment that is sought to be enforced in Ghana. It must be supported by an affidavit which shows that the judgment is a final judgment of a court of competent jurisdiction. The affidavit must also state the name, the trade or business, and the last usual known place of residence of both the judgment creditor and the judgment debtor. The affidavit must also state the following: that the judgment creditor is entitled to enforce the judgment, that at the date of the application, the judgment has not been satisfied, that at the date of the application, the judgment may be executed in the foreign country, and if registered, is incapable of being set aside. And it must also indicate the amount of interest that is due under the judgment up to the date that the application is made for the judgment to be registered. Finally, the affidavit must be accompanied by proof that the judgment may be executed in the foreign country. The application is also required to prove the foreign law that governs the interest over the foreign judgment. So in this instance, you need a certificate from the foreign courts that gave the judgment that is sought to be enforced, that would confirm that indeed the judgment is capable of being executed in that country, and also a certificate that will confirm that interest is due on the amount that is due from the foreign courts. When leave to register foreign judgments is granted, the court that grants the leave would also make an order requiring that the judgment debtor, so that means the person that you seek to enforce the judgment against, is personally served with a notice that the court has granted an order to register the judgment. A registered judgment will have the same force and effect as a judgment that is given in Ghana. So in this instance, even though it may be a foreign judgment, a judgment obtained in the United Kingdom or Spain, once the court grants leave for it to be registered in Ghana, we will enforce it in the same manner as we enforce a judgment given by the Ghanaian High Court. So we'll go through the same usual execution processes. You can file a writ of FIFA, garnishee proceedings, etc. may be done to enforce that judgment. Typically, the order granting leave to register a foreign judgment will state the period within which an application may be made to set aside the registered judgment, and must also contain a notification that the judgment may only be executed after an expiry date that the court that grants leave to register the judgment sets down. The court may extend the time within which an application may be filed to set aside the registration, and the application for extension of time may have to be made within the time that the court gave the judgment letter to apply to set aside the judgment. So what this means is that the courts will normally, when giving registration, leave to register a judgment, will give a period within which the judgment letter may apply to set aside the registration of the judgment. So within this set period, if the judgment letter is unable to apply to set aside within that period and wants to extend the time, the judgment letter must do so within the period that the court has set down to apply to set aside. If that is not done, you may not be given an extension of the time to apply to set aside the registration. Notice of the registration must be served on the judgment letter and must contain the full particulars of the judgment that is registered and the order for the registration. It must also contain the name and the address of the judgment creditor, or the name and address of the lawyer of the judgment creditor. It must also indicate the rights of the judgment debtor to apply to have the registration set aside. And it must also indicate the period within which an application to set aside the registration may be made. After service of the notice of registration on the judgment debtor, it may apply to set aside the registration. And the courts will normally set aside the registration where the judgment falls within any of the cases where a judgment may not be registered, or it is not just inconvenient that the judgment should be enforced in Ghana, or that there is some other sufficient reason for setting aside the registration. The foreign judgment is not a judgment to which the court as applies or was registered in contravention of the Courts Act, or in instances where the original court may not have had jurisdiction to give the judgment in the first place. So if any of these conditions are met, a court may grant an order to set aside the registered judgment. One other instance to where the courts may set aside the registered judgment is where the judgment debtor, being a defendant in the proceedings in the original courts, did not receive notice of the proceedings in sufficient time to enable the judgment debtor to defend the proceedings, and because of no insufficient notice did not appear, or where the foreign judgment was obtained by fraud. The enforcement of the foreign judgment will be contrary to Ghanaian public policy. We have already explained that the Ghanaian courts will not aid an illegal or immoral act. So if the judgment relates to an immoral or illegal act in Ghana, it will not be, and it may have mistakenly been registered. The court has the power to set aside such a judgment. And if the court is satisfied that the matter in dispute in the proceedings in the original courts had, before judgment was given in the original court, being the subject of a final and conclusive judgment by a court which had jurisdiction in the matter. When an application is made to set aside the registration of a foreign judgment, execution is stayed until after the application is finally determined. So if the court registers a foreign judgment and the judgment debtor applies to courts to have the registration set aside, the courts will not allow the judgment creditor to go into execution of the foreign judgment. The courts will have to abide the determination of the application to set aside. So the judgment creditor will not have the right to go into execution, but the judgment creditor will have to wait for all the proceedings to be concluded before, if the court gives it leave, it goes ahead to execute the judgment. Normally, one may ask, how long would it take for an enforcement following registration of foreign judgment? Typically, this will depend on the number of cases pending before the courts. Depending on the court schedule, there are a lot of cases pending, then this will affect the time. If maybe there are interlocutory applications that may be filed, that will also affect the time that the foreign to complete the registration and enforcement. But typically, enforcement will not take less than 3 months, usually maybe 3 months or more. Also, judgments in foreign currency would have to be converted into Ghanaian currency. So if the judgment is in pounds or in dollars, once you are registering the judgment to have it enforced in Ghana, we would have to convert the currency into Ghanaian currency. And this will be done at the rates that was prevailing at the dates that judgment was given in the foreign courts, and not the dates that you apply to register the judgment. So the conversion rate will be the rates at the time of judgment and not at the time of registration. A judgment creditor is also entitled to interest on the original amounts, as if the judgment had been given in the Ghanaian courts. The Ghanaian courts will award interest up to the time of the application for registration and not thereafter. So interest would accrue up to the days that you seek an order in Ghana to have the foreign judgment registered. And the court will also not look into the merits of any decision, foreign judgment that you seek to have registered. The courts, all that the court does is to ascertain whether there is a reciprocity agreement between Ghana and the country whose judgment is sought to be registered. And once there's a reciprocity agreement and all the conditions are met, the court will register the judgment. However, if there's no reciprocity agreement between Ghana and the country whose judgment is sought to be enforced, then that judgment cannot be registered in Ghana. And a judgment creditor will have to institute fresh proceedings in Ghana and then use the judgment that was obtained in the foreign court as evidence in those proceedings. A foreign judgment may be registered in the High Court within a period of 6 years from the time that the foreign judgment was delivered, or in the case of an appeal, after the last judgment in the appeal proceedings. The Ghanaian courts are also empowered to order the judgment creditor to provide security for the cost of the judgment debtor in any proceedings that the judgment debtor may bring to set aside the registration of the foreign judgment. In fact, these are some of the basic things that one needs to know in enforcing a foreign money judgment in Ghana. For more on this, visit our website.